everybody. We're going to go ahead and get started with the next section. So we're a little bit behind, so we want to go ahead and jump right into the next session. FEMA's Public Assistance Program, Disaster Assistance for Public Entities and Private Nonprofits. And please welcome Ms. Michelle Zaltsberg and Ernie Abbott.
Thank you very much. I guess I should bring up my notes. Apparently you don't have bios, so I'll just say I've been a sort of a federal government law lawyer since 1978 or 9. My first experience with disaster law came in 1997 when I was appointed the General Counsel of FEMA at a time when FEMA reported to the President. So that was quite an experience. It's pretty extraordinary that 27 years later, I'm still laboring in the field of disaster law. And you might wonder what it is that makes disaster law interesting. First, as your presence here demonstrates, disaster law really is focused on helping people and communities in times of distress, when they most need help. So the mission is something that we really can believe in, and that's certainly a big motivation. But the second one is I find disaster law truly fascinating legally. And I think that's an important thing to stress. We are here speaking at a law school, wondering what is the role of lawyers in disasters. So the second piece is that disaster law is an area where you get to the Constitution faster than about any other field of law in a lot of different ways. First, there's the balance of power, or the tension between state and federal governments, federalism. It is the state, not the federal government, that has the police power. The police power is reserved to the states under the Constitution. And so implementing any kind of disaster law regime will involve cooperation and coordination between two levels of government, and sometimes they don't necessarily agree with each other. So you have to try and paper over those disagreements in a way that will provide for the mission to continue. Second, there is the tension between the President and the Congress, the executive branch and the legislative branch. Under the Constitution, it is the Congress that gets to enact law and the President that gets to execute the law. In emergencies, in disaster situations, you invariably run into situations where the executive is going to be tempted to take actions that may not necessarily be spelled out clearly in the law books that are out there. And so you have this tension about how do they act lawfully when what it may appear is that the law is very difficult to comply with while you are protecting the public health, lives, public health, and safety. Another, we can move one page forward there. Another kind of a tension is between the relates to the power of the purse. Excuse me, I got so interested on the first page that my pages weren't particularly ordered. It is the Congress that gets to appropriate money. It's the President, the federal government, the executive branch that gets to spend the money. It's even a crime for a federal official to spend money that hasn't been appropriated. So what do you do in emergencies where all of a sudden you have to suddenly take a lot of actions, and a lot of those actions cost money without violating the laws. And the answer really is the Stafford Act in terms of how it's handled within the United States, along with a bunch of other emergency authorities that really don't involve the public assistance program that we're going to deal with here. The Stafford Act allows the president, which is delegated to FEMA with one exception, to waive the application of a whole bunch of different laws. It also provides for exclusions from specific laws that Congress may have spent many years and many controversies enacting, one of which is the National Environmental Policy Act. There are actions taken in emergencies where it is excluded statutorily from NEPA. The Stafford Act also provides authority, extraordinary discretionary authority of the president to take emergency actions, which cost a lot of money, and to provide assistance to state and local governments and certain nonprofits to take actions that cost a lot of money. And it does so by authorizing it. And you've got to be careful about what does the language it says. The president may direct any federal agency to provide assistance, or the president may provide assistance to state and local governments in order to save lives and protect public health and safety. It's a really broad authority. You're sort of, as a general counsel of an agency with that kind of breadth of authority, you're always wondering, how are you going to decide when I spend the money, when I don't? When is enough of a threat to public health and safety that I'm going to spend money, and when do I not? You've got an ice axe on a hill, and you stick your ice axe in the side of the hill saying, okay, this one, it deserves eligibility of funding, but I'm not going to do any more. And each year it seems that the ice axe slips a little bit down as you get more and more comparable situations. And then the second thing that you have authority to do with respect to the public assistance program is to fund the repair, restoration, reconstruction, or replacement of disaster damaged facilities to eligible entities. And we'll get into who's eligible or not a little bit later. But that is more restrictive. You are repairing disaster damage, so you have to be able to figure out what is disaster damage. How well are you going to repair them? Do you have any public policy concerns with making the facility twice as good as it was before? What was the responsibility of the owner of the facility who had allowed that facility to depreciate to where it was in very bad condition? Are you going to give them a brand new, as new facility or not? And will there be any political fallout? It's actually political fallout more than legal fallout that ends up being significant in the public assistance program anyway, because virtually all of the decisions that FEMA makes in order to grant money are discretionary decisions as to which there is sovereign immunity. So many of these important issues are ones where you can't go to court. Remember, there was a decision in an immigration emergency, which was declared decades ago, in which detention facilities were spent with FEMA money for immigrants coming over from Cuba in Florida. That it met all of the statutory criteria, but it was something that the Congress didn't like at all. And somehow that disaster or emergency declaration has never been repeated. And in fact, until I pointed it out to the Library of Congress, you couldn't even find it on, the Congressional Budget Office. You couldn't even find it on FEMA's website. The declaration had disappeared for an immigration emergency. There's two other tensions that we want to talk about as we go through the technical details of the public assistance program which can get pretty detailed. One is the tension between the governmental power to protect the public health and safety and individual rights. Most recently in the public health scene, we've seen the most extraordinary debate about that tension in my professional life, certainly. We all knew that under the Jacobson Doctrine, decided in, I think it was Jacobson versus Massachusetts in 1907, in the Supreme Court, the Supreme Court declared that there was a power of the government to force vaccination of individuals for smallpox, and that prevailed over the individual right. But in the last 3 years since COVID, we've seen more litigation, including several cases in the Supreme Court, in which that collective power has been limited by the Supreme Court as it relates to how much the executive can do to protect against COVID in terms of restraining the owners of facilities from having more people in their facilities. So that's one tension which will come up, and it comes up with the public assistance program, because many assistance programs for COVID response are administered through the public assistance program. And then second, there's a big tension between providing assistance to those who are distressed by a disaster, who are victimized by a disaster, who've lost their homes to a disaster, and the incentives that Congress has put into law, or that FEMA has placed, to try and encourage individuals or communities to take action to prevent it from happening again. One of these tensions you could imagine is in the flood insurance program. The flood insurance program, you are required, if you live in a special flood hazard area or a community is there, you are required to get flood insurance if you're going to get any kind of bank that's in any way financed or supported by the federal government. This is called the mandatory purchase requirement. In 2012, Congress, trying to make the flood insurance program more actuarial, increased the insurance rates for those living in flood-prone areas to actuarial levels effective immediately. And so you had a program where some homes that had been paying several $100s, $400, $500 a year for insurance suddenly were paying $8,000, $10,000 a year for insurance. And so you have this tension between people who lose their homes to foreclosure in order to protect them from losing their homes when the flood happens in the future. So that's one of the kind of tensions which you can see in disaster law. So now I'll talk a little bit more specifically about the public assistance program that you've probably read this slide already several times, wondering when I was going to get to it. There's basically two big pieces of the public assistance program. One is emergency protective measures, which basically says if you're taking actions to protect lives, property, and public health and safety, and there's a long list of things in the statute that get covered by that. And you have to be able to show it's an imminent threat. And the second is debris removal. FEMA even calls Category A debris removal. Category B, emergency protective measures. And debris removal accounts for, I think it's somewhere between 25%, 33% of the cost of any disaster, obviously with the exception of something like a public health disaster like COVID. And then the second half of the public assistance program is the restoration of disaster damaged facilities. Not that the first one, it doesn't have a lot of restrictions in it. It said whatever the president decides is necessary to save lives, property, the public health and safety, you're providing assistance and so forth. But for the repair of damage, it's the president may provide assistance to eligible applicants to repair, restore, replace, and reconstruct the disaster damaged facilities with a lot of restrictions, which we'll get to a little bit more. And we're not going to really go over all of the slides that we have because you're going to get it in the download, or what, it'll be uploaded, so you all will be able to get it. It includes some reference slides, so you'll be able to find it. And a third piece in the public assistance program is hazard mitigation measures. And that's distinct, since we're only talking about the public assistance program, from three other FEMA programs that provide funding for mitigation. The flood insurance program has its own flood mitigation assistance fund that is funded out of flood insurance dollars. There's the hazard mitigation grant fund, which has been along for a while, and that is based upon a percentage of disaster damage. It creates a fund for mitigation. And then there's a new rebuilding resilient communities. I can never remember what the BRIC program initials actually mean. And that is an extraordinary new pre-disaster program based upon the sort of 6% of the amount of disaster expenditures in the prior year that FEMA is in the process of implementing. And given the scale of disasters we've been experiencing, provides billions and billions for disaster mitigation, much greater than the maximum of $30 million that was appropriated for mitigation when I was, pre-disaster mitigation, when I was at FEMA. The Section 406 public assistance program hazard mitigation measures are ones that relate to while you're rebuilding something, that's the best time that you should look at it and say, you don't want to rebuild this the way it was before, because it'll just get damaged again. So we're going to rebuild it in a way that will be resilient to disasters, more strongly built and so forth. It does have a cost effectiveness test. Next slide. So I'll talk very briefly, because I think most of the audience is familiar with the individual assistance program and not the public assistance program. What are the differences? I'll give the one thing which is the same, which is really important to remember. These are grants. They are federal grants based on eligibility and not competition. So the federal grant piece is important because that means that the federal grant regulations which apply across the board to any grants in the whole federal government are the grants that apply to both the individual assistance program and the public assistance program, and they were definitely not designed with disasters in mind. They're sort of all across the board regulations, and FEMA and its Inspector General have been increasingly diligent in making sure that you pay attention to those grant regulations in 2 CFR Part 200. And second, most of the federal grants that are at least discretionary, as opposed to things like Social Security, those programs, are competitive. Congress appropriates an amount of money, the agency puts out a notice of funding opportunity or something saying, hey, I want proposals for people who want to get this money and spend it for the purposes of the grant, and then we'll pick the best ones. Both the IA program and the public assistance program are eligibility based. The following are the things we will pay for. You just have to show that you meet all the criteria. There's no funding cap. And that's, again, because you had this disaster relief fund that's been enacted to pay all the money. I think the major things I'll mention, that the fact that it is a pass-through program. So unlike the individual assistance program, you're basically dealing with FEMA and its individual assistance directorate. For the public assistance program, the state is in the middle between the eligible applicants and FEMA. So all of the grants go through the state manages sub-grants to all of the individual assistance. So that's something that's important to remember. The public assistance program also has a cost share. The federal only funds 75 up to 90% usually of the cost of the funding provided, and the rest of it has to come from somewhere else. And the state, at the very beginning of the disaster, signs a FEMA state agreement in which it pledges that there will be non-federal funds that go to pay the non-federal share. And that's a significant component of the program, and one which is increasingly difficult when you're dealing with communities that are so affected by the disaster that they don't have the money to pay the cost share. Next slide. I think that's you.
Hi, I'm Michelle Zaltsberg. Thank you, Ernie.
Oh, and I forgot to mention that I think Michelle is one of 2 lawyers that I know of in America who became shareholders in a major law firm based solely on FEMA work for representing state and local governments and nonprofits.
Thank you, and I think that's because our group is one of the only groups that practices disaster law, so I appreciate that accolade. I am Michelle Zaltsberg. I work at Baker Donelson on Ernie's team. I'm in the Orlando, Florida office. And I'll just give you kind of a brief 30 seconds on me. I started my career in Atlanta, Georgia, doing major complex insurance defense, and had a boss who made me write articles, and so I had the words tornado and hurricane on my resume or on my bio, and Ernie needed help, and I got a random call. I was doing business litigation at Baker Donelson at the time. And they said, you have catastrophes on your bio, can you help Ernie? And I've been a disaster lawyer ever since, so it's now almost 10 years, and I love it. I think it's the best private practice work a person can do, just in terms of level of stress and feelings of doing good work. Work-life balance is really good. And I guess the point of that is if you're a young lawyer in the room, be willing to answer the phone and say yes, and you never know where you might end up. So our practice is public assistance, as Ernie just described for you. Sometimes we get calls from individuals who find us on the internet, and I refer them to legal aid. So, we really don't practice in the IA field at all. And public assistance is authorized under the Stafford Act, which if you do IA, you'd be familiar with, and regulated at 44 CFR Section 206. So that's just a reference for you if you're interested in learning more. And it really all starts with a presidential disaster declaration. So y'all may be familiar with this aspect where disaster strikes and there's a preliminary damage assessment that's usually joint between the federal government and the state. And the state governor makes the determination that the damage is beyond the scope of the state, beyond the capabilities of the state to respond, and asks the president to make a disaster declaration. If the president does, he'll, or she, one day, will describe within there the type of incident, the incident period, and designate areas, usually counties or parishes, depending on where you live, that is eligible for the assistance and the type of assistance. So sometimes we see only direct assistance from the federal government. Sometimes that's in the form of mission assignments, for example, by the Army Corps. Sometimes it's direct housing assistance under IA, and then sometimes it'll be public assistance. And in a smaller hurricane, you might only see, public assistance approved for just that emergency work. We're not going to rebuild your buildings, but we'll clear the debris and we'll fund emergency protective measures, sheltering and that sort of thing. And then other times for more severe incidents, we'll see public assistance permanent work. And we'll talk about that. The president will also designate a cost share, which is at a minimum 75%. We've seen it go up 90 to 95, sometimes 100. I think Katrina might have been the first in recent memory that was 100%.
And that was by special congressional legislation.
All the way through.
Overruling the president.
Yes, and then we've seen it more often in the more severe storms since then. Ernie mentioned that the FEMA Public Assistance Program is a pass-through program. So what that means is there is a recipient, a subrecipient, the recipient always being the state agency that's designated. Well, it's always the state, and then they have a state agency that's kind of designated as the grant manager for the state. So in Florida, it's the Florida Division of Emergency Management. And then each state, local, state agency, local government, private nonprofit is considered the subrecipient. And so there's a contractual agreement at every level. And an applicant can either be the state or a subrecipient. But the applicant is the entity that's applying for that public assistance. We talked about categories of work. So within public assistance, FEMA kind of identifies every type of work with a different letter. Categories A and B are the emergency work categories. That's debris removal and emergency protective measures. And then permanent work is your categories C through G. And that is the work to restore buildings, to restore infrastructure, and that sort of thing. And FEMA has a lot of guidance, a lot of policy that explains all of the rules, particularly with respect to permanent work. And over time, they've, published gobs and gobs of guidance and then condensed it all down and archived the rest. And then it kind of grows again, and then they condense it all down and they get rid of it, the extraneous parts. And so what's really interesting is in this line of work, you'd think, okay, a hurricane damages a building and they have to rebuild it, and what could go wrong? What could be different from case to case? Really, every single matter is different. Every single community is different. We have eligibility issues. We had this building, but it was a library, and now we want to use it for a community center. Or we had a community center, but we had planned to rebuild it anyway, and then it got destroyed. Can we still do it? And these kind of really interesting issues pop up. And sometimes there's really good guidance on it, and sometimes the guidance is gray, and that's where we kind of come in to make the best case as to eligibility.
I'll just note category G includes engineered beaches. In fact, we're filing today a response to a FEMA denial of reconstructing, restoring a dune that provided several feet of flood protection to improved property that the dune had been damaged by Hurricane Ian. No, this is, don't tell me, this is Irma. That's another thing that you should remember about the public assistance program is the decision that is supposed to happen quickly takes a long time. So the whole issue is whether this work to restore the dune was category B, emergency work to protect against flooding from a 5-year storm, or category G, permanent work to restore the facility to the condition it was in prior to the disaster. So that is now in arbitration before the Civilian Board of Contract Appeals, and maybe gives you an idea of what kinds of issues can show up that you wouldn't necessarily think of.
Yeah, and the lag is real. When I first started doing this work, I think one of the first projects I worked on was out of the 04-05 hurricane season, and we actually are still working on that matter. It's sort of narrowed, but it's now, I think, 17 years post-disaster, and it's still not settled. So these things, our Hurricane Ian work, for example, isn't really voluminous yet because there is such a lag in the decision time it takes FEMA to make these calls. I pressed this button, but it didn't go forward.
Yeah, while you're going forward, I'll say that these delays can sometimes be really problematic because of the way the program is structured as a reimbursement money, where you have program where you have to spend the money first and then you'll get reimbursement. And if you don't have the money, then you don't get to spend the money, and so you have trouble getting reimbursement for it. And this has been a big challenge in Hurricane Irma and Maria in the Virgin Islands and Puerto Rico, and then some communities in Florida. But you just have to think about the cash flow issues in an environment where the federal grant process isn't thinking of it that way.
And so we're talking a little bit about, I think in the last slide we had FEMA's sort of eligibility pyramid is what they call it. And eligible work is part of that. So what constitutes eligible work is work that's required as a result of the disaster. And that comes up quite a bit. So FEMA is saying, well, you can't prove that the hurricane that swept your roof away, well, we can't really know that that was disaster related because we don't know the condition of the roof before the hurricane came through. So provide us with, photos and maintenance records and all of these things to show that your roof was in good condition before the hurricane came through. It comes up a lot in roads, especially rural counties, where they're not necessarily equipped to have the resources to send drones over their roads every year or have people photograph every mile of roads. So, we end up submitting the affidavit of the road engineer that says, well, I drive the roads every day and they look good to me. And we hope that FEMA will, accept that as evidence of pre-disaster condition. But a lot of these local communities don't have the resources to provide the documentation that FEMA needs, or I shouldn't say needs, but demands, in order to substantiate the claim for public assistance. So that's become a really big issue.
I'll just make my one
Sure.
comment that I really like to make about result of the declared incident. We had a situation, actually, while I was at FEMA, where a city bus agency requested reimbursement of the cost of replacing the underground storage tanks that had been damaged by the disaster. And that was moving along well until photographs emerged of the underground storage tanks that had already been removed from the ground because they had been leaking, but the pictures were taken before the earthquake. So you clearly have a situation where the leaks weren't the result of the disaster. Mm-hmm. We've recently had some issues about, is the cost of financing several $100 million that were spent to perform eligible work, we'll call it, is the cost of financing something that was required as a direct result of the disaster? You didn't fix anything with the cost of the financing. No, you got the money that you would be able to pay to fix it. And so that you can get that kind of an issue which will show up.
And another kind of really interesting one we worked on was out in California there was an earthquake. And instead of having everybody push their debris to the side of the road like you would in Florida, your debris is inside your house. It's not outside your house, right? It's plates, it's construction materials. So why would people put that on the side of the road? Instead, they said, bring it to this centralized location and drop it off, and then that way we don't have now a second disaster of having debris all over the road. Well, FEMA said, well, how do we know all of that broken china was a result of the earthquake, right? As if everybody in the Napa County went out and slammed their dishes at the same time. And they denied $1 million worth of debris removal because of the way that it was done. And, they said, well, we don't know because the debris truck wasn't at the person's residence. How do we know somebody from some other county didn't come and deposit their debris at this communal debris drop-off? We can't say that it was within the designated area, and we can't say that it was, disaster damaged. That was a pretty egregious decision in my view. I think they could have found a way to yes, but those are the sort of the things that come up. And, the guidance is often written with hurricanes in mind, not with earthquakes in mind, or not with fires in mind, not with pandemics in mind. So, with every kind of new an interesting disaster, I think we get a little bit more clarity on what to expect from FEMA. And the legal responsibility question, too, is really interesting. That comes up quite a bit. We've had cases where, maybe a private operator has a lease on a public facility, and the lease says something like, if there's a disaster, you have the option to either fix it or to walk away. So then whose legal responsibility is it? We have to then kind of say, well, they made the choice to walk away, and that left the public entity with the legal responsibility to do the fix, and that's why they're eligible for public assistance. And that might be, part of the decision-making between the leasing parties as to whether they stay or go. So each one of these items has the potential for dispute, which makes life interesting for us. The next...
And provides a role for the lawyer.
Yes.
I'm trying to focus on what the lawyers do in disasters.
Eligible facility is the next question, and that is the facility, one that FEMA is even willing to fund the repair, replacement, or, restoration of? Is it a public facility? Certain private nonprofit facilities are also eligible if they provide a critical service. Houses of worship became eligible more recently that provide certain critical services. And that's been one where, FEMA has to look and say, okay, well, which part of this facility is purely for religious purposes and which is for critical services, and we need to divide up the eligibility in that way. We have one we're working out where it provides pre-K services, which are defined as primary education under state law, but FEMA has said, well, pre-K is not primary education, and only primary education is eligible. So, there's a lot of issues there. In COVID, it came up a little bit because we had private hospitals that said, hey, how come we're not eligible for this public assistance funding? We're doing this service to the community of providing emergency protective measures. And FEMA, I think maybe for the first time, has come up with guidance that says very clearly that a private hospital can benefit from public assistance, but they have to contract for the services with a public entity. So they can enter into contract with the state, and there has to be, they've even now allowed, recent guidance says they can come up with retroactive agreements that say, we kind of delegated this authority to you to have the legal responsibility to respond to the public health emergency. So I think there was a lot of pressure from the private hospitals there as well. And then the next big question, and this is where I think most of the problems come from in public assistance, is eligible cost. Did you want to talk about that, or you want me to keep going?
Oh, you can read what it says on the slide. On that eligibility pyramid, you say, okay, are you an eligible applicant? Is it an eligible facility? Is the work that you're doing eligible, which is repairing the eligible facility? And then you get to the question of cost, which is how much did you pay? Because they're worried about the gold plating of repair costs. So they say, you can submit a whole bunch of invoices and costs. It is the work that you did, the work that was approved that you should do in the project. And then there's this great regulation. I think it's 2 CFR 200.403G, just it's pretty remarkable I could remember it, which tells you that the costs have to, quote, be adequately documented, close quote. That is the entire length of the regulation. Obviously, what is adequate? And how do you determine what is adequate? If there's a contract for a fixed price to perform particular work, is it adequate to just show you did a competitive proposal, you picked the cheapest bid, you paid the contract price? Or must you provide all of the underlying documentation of what the contractor paid for labor, materials, everything else? Some FEMA offices are now saying we need to provide all of that underlying detail, which is something you may not easily get from the contractor. reduced by all applicable credits. So there's always this effort to encourage people to get insurance. Does the insurance cover the damage? If it does, then it's not subject to disaster assistance because you have another available fund. That makes a lot of sense. FEMA has also experienced situations where, let's say, the negotiation on how much the insurance company pays seems to be ended up lower than what the policy seems to provide. And so FEMA has said, well, we can interpret the insurance policy, and so we're going to assume that you had $200 available to you for insurance, even though you ended up agreeing to take only $100. So we're going to reduce our grant by that $100 amount. Salvage is something that's too complex to get into, but if you create this gorgeous facility or used expensive equipment in order to build it, and then you've finished the building or the equipment and you've still got some left over, you're supposed to reduce how much your disaster money is by the amount of salvage you could get for it. And then there is one really significant theme that FEMA wants to pay for things that are not, let's say, jiggered to get more federal money. And so if there's a code and standard where you are allowed to build in accordance with a particular code and standard, it's supposed to be a generally applicable code or standard, not one that is effective only when federal money is available. You know, they want to make sure that you, the community, believe in the code or standard. There have been some changes in that particular policy with respect to codes and standards because the Congress put in some authority for FEMA to say, no, we're going to pay for a particular kind of disaster resilient code, even if you haven't gotten around to adopting it. And then necessary and reasonable, I don't need to say much about that. In terms of eligible costs, you can imagine that it costs a lot of money to comply with all of the documentation requirements and the grant requirements. Most communities end up, particularly in Florida, engaging with a disaster management, grant management consultant who will track all of it. And under the Disaster Recovery Reform Act of 2018, a Trump administration reform, the applicant gets 5% of the total costs, essentially, that they can use to pay for 100% of the cost of your disaster grant management consultant. The state level people get another 7% because they have a few more responsibilities than just the ones of the applicant.
So we talked a bit about reasonable costs. We mentioned it as being part of the eligibility criteria for costs. And this is something that is really kind of the crux of a lot of our issues. The regulations that are applicable to grant funding define reasonable cost as if in its nature and amount it does not exceed that which would be incurred by a prudent person under the circumstances prevailing at the time the decision was made to incur the cost. Ernie and I were on a team of lawyers and consultants that helped Puerto Rico after Hurricane Maria. And one of the things that we were tasked with doing was reviewing every procurement to make sure that it complied with this set of regulations. And there were a couple times where we were asked to look at a contract amendment for power restoration that was in the
Say $945 million sole source contract?
Exactly. And you can imagine being, sent that and asking to sign off on that. And, a really kind of intimidating thing to say, well, a prudent person under the circumstances would say yes to this. Not competed, nearly $1 billion. But at the same time, the island was still suffering. People were still suffering, and it was an emergency situation. And I think one of the things we can say is that there was independent review that also determined it was reasonable, so we're happy that it worked out. But this is a issue that comes up a lot, and these are the things that FEMA will look to determine if the cost was reasonable. Is it generally recognized as something that's ordinary and necessary? It kind of goes back to what Ernie was saying, taking advantage of Uncle Sam. Is it something that you would normally need, or are you procuring it just because Uncle Sam is going to pay for it and federal tax dollars are available? Is it comparable to what you've paid in the past, what your neighbors are paying, average costs in the area? Sometimes in a disaster situation, the costs are not typical of what you would normally be paying. We have a lot of applicants for K95 masks who paid way more than they ever would have they were buying them off the back of trucks, right, at a certain time. Prices were fluctuating by the minute. They would get a call and then, that masks were available, and within hours it wouldn't be. So they had to just say yes. So that's one that comes up a lot. Again, supply shortages, and then, things that they're going to look for, whether or not you're buying your supplies from your brother-in-law. That would obviously undermine the reasonableness of the cost. And procurement compliance, because at the end of the day, robust competition is the best evidence of cost reasonableness. And there is a presumption that if you competed the cost on the open market, that it is reasonable. And this is what you'll find if you look up what the procurement standards are under the federal grant rules. These are applicable to public assistance. And I would say probably 30% of our practice is dedicated to this set of regulations. Local governments who call and say, I want to hire a construction manager, I've never done that before. How do I do it compliant with this set? Or they'll say, my local regs allow me to make a sole source purchase at this threshold, but the federal threshold is different. What do I do? And so procurement compliance is a really big deal. It's become even more of a big deal because of the Office of Inspector General, who in 2016 issued a report that said, we've found procurement noncompliance in millions of dollars of FEMA public assistance grants. And 91% of the time that we've told FEMA that these costs were spent outside of the procurement regulations, they've ignored us and they've given the money anyway. They haven't clawed it back. And the OIG said the reason why procurement is important isn't just reasonable cost, but there's other regulations in there. Let's see, it was 200.321, contracting with small and minority businesses. If you just award reasonable cost, you're not effectuating the purpose of that policy, right? You skip over where you're supposed to give opportunities to women-owned businesses, small businesses, minority-owned businesses, and you just say, well, the cost was reasonable, so it doesn't matter. And the OIG said that's not the purpose of the regulation, to just be okay with reasonable cost. You have to also, do the things that are important to the policy. And so they actually used the words, they said, better enforcement would motivate recipients of federal funds to follow the rules. I think they said something like a financial incentive. So they basically said, you need to start taking our recommendations. And in 2021, again, they found procurement regulations non-compliance was among their most significant findings, and said again to FEMA, stop allowing determinations of eligibility just based on reasonableness. And FEMA has listened. They've started denying costs, at least in our practice, we've seen it more and more, based solely on procurement noncompliance. So this has become a really big area of importance. Ernie,
I'll take over here because I am in fear of the hook. We started a few minutes late, so we may have a little bit of time. I just want to focus on a couple of things that you really need if you happen to be dealing with local governments, state governments, on FEMA issues. What are the things you want to make sure you pay attention to? One is don't miss a deadline. FEMA has now said we have an administrative appeal process, gives you 60 days after you get a determination. You have to file your appeal within 60 days or you are gone. It's viewed as a jurisdictional loss. So that's your malpractice insurance talking. Sometimes it gets difficult because the FEMA people on the ground may be trying to say, hey, we're still working this out. You may be still working it out, but if you miss the 60-day deadline, you're gone in terms of having any ability to raise that issue. Second, we're seeing more of the other deadlines. The deadline to file your request for public assistance, which is really mostly a contact notification document. Your deadline to complete emergency work. We've seen them arguing in a number of contexts that if you don't finish it within 6 months, you are no longer eligible, unless you had applied for an extension and it was granted. Second, failing to maintain required insurance. One of those conditions to try and give an incentive towards preventing it in the future is that in order to get a grant for public assistance, you have to agree to obtain and maintain insurance at least as much in amount as the amount of damage to your facility in the disaster that you got funds from. And if you fail to do that, and this happened to one university actually in the last several years, they had received a $14,000 public assistance grant on flooding to a building. 4 years later, they received another $12 million of damage to the same facility, but they'd never gotten around to getting insurance for the $14,000, and so they were ineligible for any assistance whatsoever. So don't fail to meet the insurance requirement. Michelle mentioned sales, leases, construction contracts. You should remember when those are being entered into that if the lease changes the legal responsibility for the repair, a lot of construction contracts, the contractor agrees to be responsible for any damage to the facility, whatever the cause, during the period of construction. If the disaster hits that facility while those lease provisions are in effect, the contractor, which is a for-profit entity, is responsible for repairs, and so only the contractor is, according to FEMA, supposed to pay for it. There will be no disaster assistance even if the contractor goes bankrupt. I would say one thing about characterizing work. FEMA is filled with all sorts of labels. If it is an increased operating cost, it's not eligible. If it's an emergency cost, it can be eligible. So what about an event which damages the electric power to your facility? And as a result, you decide, I'm going to go buy my power that was damaged. I think Rob Burchuk had a picture of the generation facility no longer generating power, so you buy power from a different facility. That would be viewed as an increased operating cost, and therefore the increased cost of that power would be ineligible. Whereas if you bought a generator and ran the generator instead of buying the cost, this would be emergency work, Cat B. See, I can get into acronyms. Cat B, emergency work, and it would be eligible. Even the fuel required for the emergency generator is eligible. A lot of the issues with COVID have come from FEMA's traditional hesitation about funding work by hospitals to provide medical care. Why wouldn't they want to pay the cost of these increased costs of medical care due to COVID? Well, a hospital is in the business of providing medical care. So if there's more medical care, more patients, wouldn't that be this more business? Why should that be something the federal government would fund? So that, I'll say, is the attitude. So they would fund, if you go have to build a bunch of ICU units on an emergency basis, they'll fund that, but not just doing the regular old medical care. And they had all sorts of issues with decontamination costs and such. And then ignoring environmental requirements. There are a lot of emergency requirements relating to environmental requirements relating to construction that are funded by federal money. And the basic position of the Environmental Historic Preservation Group is that if you go forward and do the work before you've fulfilled the environmental requirements, even though the work would otherwise have been eligible, you are ineligible for assistance. So that's one which can be fatal.
And I think we only have a couple minutes left, so I'll just kind of tell you what you'll find in our slide deck when you look at it later. I'm sure you will, which is this is the FEMA project workflow. If you're interested in what the actual steps are of how you formulate a project for public assistance and decide what your damage is and how you're going to scope and cost it, you'll find it here. And then moving toward obligation. And if unfortunately you get to that obligation step and it doesn't go your way, then you are potentially eligible to file an appeal, which is basically a letter that you write to FEMA and you explain why they're wrong in their decision. Again, there are very strict deadlines for filing that. There's also statutory deadlines for FEMA to make decisions, which they never meet. But they will not hold you to that same standard, so make sure you don't miss yours. More recently, there's now a right of arbitration. It used to be limited to Katrina and Rita and then in Sandy only, but now we have it for all disasters after, I think, January 1, 2016. And that lets you take kind of bigger disputes to the Civilian Board of Contract Appeals, who will hold you to all your deadlines, and FEMA. And it's a very fast-track decision process. About 164 days from filing your request for arbitration to getting a decision. And those judges have become very familiar with FEMA issues. They see the same lawyers over and over again. They want to hear kind of like the quick and dirty version and make a decision. So it's something that's attractive to applicants for public assistance who are just waiting for finality. So that's a good one. Did you want to make
and I'll just close with what I mentioned at the beginning. FEMA is operating under a statute that says the president may do something. He may provide assistance, may direct federal agencies to do this. The regulations are very careful to say you may be eligible, but maybe you're not. And FEMA, in its wisdom, has governed all those rules in the public assistance program and policy guides, saying these are the things we probably will do, and we certainly will deny you if you don't do them. But if you went to court with respect to a denial of your request for assistance, you will be tossed out for want of subject matter jurisdiction because of sovereign immunity. There's been no waiver of immunity. Even under the Administrative Procedure Act. And there are some tricky ways you can try and get federal court review of FEMA decisions, but it's not of the decision to actually grant assistance unless it's a constitutional challenge. But with that, we'd be happy to answer questions before the shepherd's hook wipes us off the deck. But I will be around through the reception tonight in case you have any questions. It is a fascinating area of law, and I hope we've at least given you some of the flavor of it. Thank you.
Thank you.